The Richard Allen Delphi murders case is already the most bizarre case in America. Richard Allen is accused of murdering two 13-year-old girls, Libby German and Abby Williams. In grainy cell phone footage, one of them videoed the man who probably did it. But is it Richard Allen? Richard Allen says he's not the guy. This was a ritualistic killing done by Odinists, white supremacists, following a Norse pagan religion. We covered that in previous videos, and I can certainly say for me, I assumed that this case could not possibly get any more bizarre. That would be just impossible. Well, buckle up, because it is getting deeper, stranger, and more mysterious by the minute. The defense is saying that the state has been hiding cell phone evidence that proves conclusively that the state's theory of when the murders happened is completely false. And they're offering up evidence about this cell phone data. Is this new evidence going to change everything for Richard Allen? Is he about to be freed because the state all along has powerful evidence that he's not the one who killed these two girls? Here's what we know. We're going to get into that tonight. Hi, y'all, and welcome to tonight's live stream. I want to say a special shout out to the first 5 in the chat who were not in the top 5 earlier this week. Connie Presley, Lee Miller, Katie W., Mel Stiller, Carol Sue, and Vicky Sin, because I wasn't sure if one of the others had already been there. So, and a happy birthday to Michael. Hope you have a great weekend. If you would, be sure to hit that like button and subscribe. We would love to have you back for more. So this week, the Delphi murders case, the court held a 3-day hearing covering multiple motions. There is so much new material for us to cover. We cannot possibly cover it in one night. You're going to have to come back next week to find out about Richard Allen confessing 61 times to doing these murders, and why the defense says these aren't even real confessions. We'll cover that next week. But for tonight, we're going to focus on the new cell phone evidence that formed the basis of the defense motion Franks 4. And don't worry, we're going to talk about what on earth Franks 4 is. But let's start with a basic fact. I want to be really clear on when the state says that Libby and Abby were killed, because that is going to become critically important in this dispute between the defense and the prosecution. So let's go ahead and start with what they said in the probable cause affidavit. Let's go ahead and put that up on the screen. This was the initial kickoff document that was filed and talks about what they believe Richard Allen did, what their evidence is. I just want to highlight a few parts so we can really get a sense of what it is that the state was saying happened. So a video from victim 2's phone shows that at 2:13 p.m., victim 1 and victim 2 encountered a male subject on the southeast portion of the Monon High Bridge. The male ordered the girls, guys, down the hill. No witnesses saw them after this time. No outgoing communications were found on victim 2's phone after this time. Their bodies were discovered on February 14th. 2017. So the girls disappeared on the 13th. In fact, what had happened was they just were taking a walk. One of the sisters of the girls dropped them off. It's just a local park with an old bridge, an old railroad trestle, and they were just there at the park taking a walk along the path. And then they didn't show up. When people went to pick them up, they didn't show up for supper. Parents, families began searching frantically for the girls. They weren't found until the 14th. They were found there in that same area, just off the trail a little ways in the woods. So, and this is where one of them, Libby, actually, it appears, filmed the person who actually murdered them, but it's very grainy and it's not really possible. In that part, there's only a voice. So let's keep going on what else was said in this probable cause affidavit. Investigators spoke with, and it's redacted, who stated that she was traveling east on 300 North on February 13, 2022, and observed a male subject walking west on the north side of 300 North away from the Monon High Bridge. same person or somebody, advised that the male subject was wearing a blue colored jacket and blue jeans and was muddy and bloody. She further stated that it appeared he had gotten into a fight. Investigators were able to determine from watching the video from the Hoosier Harvest Store that blank was traveling on CR 300 North at approximately 3:57 p.m. So this is talking about what the prosecutors believe is a sighting of Richard Allen after he murdered the girls. So moving back, what they believe is that here at this part at 2:13 p.m., the girls are still alive. Libby is using her phone and she does that video. And then they believe that this is Richard Allen seen with bloody and muddy clothes. And that's at 3:57 p.m. And don't worry, I've already started us a timeline in this. We'll get to that in just a minute. So that 3:57 p.m., that's the bracket between those two times, 2:13 and 3:57. That's when the prosecution believes these murders occurred. They were all over and done, and Richard Allen was walking away by 3:57. They interviewed Richard Allen, Mr. Allen, in 2017. That narrative stated Mr. Allen was on the trail between 13:30 and 15:30. So he acknowledged being on the trail in that very time. Investigators observed a vehicle that resembled Allen's 2016 Ford Focus on the Hoosier Harvest Store video at 1:27 p.m. traveling westbound on CR 300 North in front of the Hoosier Harvest Store, which coincided with his statement that he arrived around 1:30 p.m. at the trail. So he's there right about the time that we see this video from Libby. And probably the single most important piece of evidence brought up by the prosecution is this one right here. They searched his home and found an unspent round. Well, first they searched the scene. They found an unspent round, bullet round, located within 2 feet of victim 2's body that had been cycled through Richard M. Allen's Sig Sauer model P226. So these are two separate events. First, they search at the scene and they find an unspent round of ammunition. It wasn't fired and neither girl was shot. In fact, one of the things we learned in these 3 days of testimony and already pretty much knew was that the way they were killed involved their throats being slit, not them being shot. So it was always a little mysterious that this unspent round was lying there at the scene. Why? Why was it there? But then they separately, using some of these facts here in the affidavit, convinced a judge to allow them to have a search warrant, which they executed at Richard Allen's home. They looked at his home and they found a gun there, the Sig Sauer model P226. When they found that gun, they matched it, they believed, to the unspent round, that it had been cycled through there. How good is that evidence? How solid? I have no idea. That's just what they allege in here. And yep, there's a little bit more. Furthermore, victim 2's video was taken at 2:13 p.m. and blank saw only one male while she was on the trail from approximately 1:46 p.m. to 2:14 p.m. And Richard Allen acknowledged he was on the trail at that exact time. Investigators believe that after the victims were murdered, Richard Allen returned to his vehicle by walking down CR 300 North. Investigators believe he was seen by blank walking back to his vehicle on CR 300 North with clothes that were muddy and bloody. That's the bracket, the very, frankly, narrow period of time when the state believes it has pretty strong evidence that Richard Allen murdered these two girls. In this very brief window of time, he's then seen with muddy and bloody clothes. It's all over by that time. So, and don't worry, we are going to put that up. So Michael Lalonde using his 4-month membership to say thank you for the birthday shout out. I hope you have a great weekend. And thank you, Linda. I appreciate that very much. Okay, so let's keep moving through the documents. So that's the states. That's what they've said all along. Now, we have new evidence that was brought out by the defense over the last few months and that was talked about at this hearing. new, not just to us, but also to Richard Allen's team. Richard Allen filed his fourth Franks motion, and they held a Franks hearing, or at least that was one of the issues to be decided by the judge, whether or not the hearing was actually heard. She said she might not use a hearing, but here's what a Franks hearing is. To get a search warrant, law enforcement gives the judge information that would justify the warrant. They can't just go into somebody's home and start searching because they think that there might be something there. They have to talk to a judge. They have to get permission to do that. And in order to do that, the judge needs evidence. He needs to be convinced there could be a reason for this. So in a Franks hearing, the defense argues that the law enforcement personnel lied to get that warrant, which means that the arrest warrant or a search warrant never should have been issued. It's hugely important here because of that all-important connection between the unspent round at the scene and the gun found at Richard Allen's house. Because of that connection, that is the most important piece of evidence that they have, even though the girls weren't killed by a bullet. So this is Richard Allen's fourth Franks motion on newly disclosed evidence here. So I'll give you a quick tour through the other three, but we are going to talk about one of the three separately, and we've already covered two of them. So Franks 1 was a 136-page long document of stunning revelations. That's where Richard Allen argued that the girls were killed by Odinists, the Norse pagan religion, that there were runes and sticks placed on their bodies, that there was a rune carved in blood on a tree near the bodies, and that all of this was a vast conspiracy to cover up, blame, and protect law enforcement. So much so that he said the prison guards guarding him were actually Odinists. He had been transferred very unusually from a jail, which is normally where a person would be kept when they've been arrested but not tried and not convicted, to a prison, which is usually only reserved for people who have actually been convicted. And he said the reason for that, he was being guarded day and night by Odinist guards, so bold they even wore Odinist patches on their clothing. We've talked in the past about how I thought that has to be imaginary. That has to be somebody just thinking that. That can't be for real. It was for real, and the state actually acknowledged it. So they have removed their Odinist patches, but there you have it. So Franks 2, the prosecution and law enforcement, this is according to the defense, tried to conceal the identity of a Purdue professor who had been asked about these runes on the body back when they were first discovered. And the defense argues that the Purdue professor contradicted what law enforcement officers claimed about no one believed it was even possible that these sticks on the bodies were runes, Norse runes done by Odinists, and that law enforcement just intentionally chose to ignore that. Now, Franks 3, which we are going to talk about, the search warrant, according to Richard Allen, omitted that 3 people were in and around the crime scene at the time the murders were allegedly taking place. And none of the owners of those phones had any connection to Richard Allen. Now, Purdue professor Jeffrey Turco also wrote a report saying that the configurations of the branches could be inspired by Nordic runes. So those are the things in Franks 3. Pretty much zero chance that the judge was going to grant any of these. And I'll tell you a couple of reasons why I think that. One is there's not exactly any love lost between the judge and Richard Allen's team. I think that's pretty clear to everybody. And in fact, I think I'm going to do a whole video on just sort of the motions they filed against each other and all of their. Boy, you should see what the judge said about the defense in one particular order. So I think it'd be really fascinating, and you'll like listening to that. So that's one reason. The other is that the judge immediately said that Franks 3 and 4, quote, will be ruled upon and not set for hearing unless necessary. Usually a judge would do that if the judge doesn't feel like there needs to be any argument. It's pretty clear how the judge is going to rule. She doesn't need any assistance from the parties. So now, in terms of whether she was going to grant the Franks motion, it may be pretty clear that she wasn't about to do that. But in terms of evidence, what we're about to go through is really bombshell. What was in Franks 4 was really bombshell, because if it's true, then it blows up the prosecution's theory. That's what Richard Allen is saying. So let's go ahead and I should have taken myself off that small picture for all of that discussion, but let's go ahead and get into our second document. This is the fourth Franks motion. And I want to say welcome to Joe Schmo, a new member. Okay, this is the fourth Franks motion filed by the defense team. And let's take a look at the first part. They just go through what the initial Franks motions were. And we're going to go through this in fair detail, and then we're going to have a timeline. So, eventually we'll get it all. It's pretty dense in terms of facts. So what they say, first of all, is that on April 26th, the prosecution provided numerous documents to Mr. Allen's counsel. The reason they bother with the date is that's kind of late, that this is shortly before trial. Really, we're within a 6-month period now, and many documents had already been provided. So they're sort of hinting this is really late. Why so late? And it had specifically included pages 2 and 3, I guess not 1, of an incident report authored by Steve Mullen of the Delphi Police Department. And here's what it's going to say. Steve Mullen contacted Sergeant Mitch Blocher of the Indiana State Police at approximately 9 p.m. on February 13th, 2017, to assist with acquiring precise location information for a cell phone using some of their more technical assets. It appears that the last communication with Sergeant Blocher was prior to 1 a.m. on February 14th, 2017. So this is, the girls are missing. Everybody is all in, worried about where they are, looking for them. And at 9 p.m., the girls have been missing for several hours. They didn't come home from the walk they took. And the local police contact the Indiana State Police and say, can you look for her phone? And that's where this all begins. They start at 9 p.m. and the last communication with the state police dealing with looking for the phone was at 1 a.m. However, as you're going to see, there are records past 1 a.m., but that's the last communication. Here is what the report says about the conversation between Steve Mullen and Sergeant Blocher of the Indiana State Police. Sergeant Blocher advised, according to his evaluation of the data provided by AT&T, the last contact event between the cell phone and the tower located at Wells Street was at 17:44:50 hours. He advised that according to the records provided by AT&T, there had been no contact with the phone since then. Sergeant Blocher advised that his interpretation of the information which we were receiving from AT&T indicated that the cell phone was no longer in the area or no longer in working condition. He advised that since there had been no change in the every 15 minutes update we were receiving, and the last known contact time had not changed since 17:44 hours. So the middle sentence there in the second paragraph is incredibly important to them, that the cell phone was no longer in the area or no longer in working condition. That's what the defense is focusing on. They're saying, wait a minute, if the cell phone is out of the area and no longer working in this period of time, why is that happening? And there's more to it than that. We'll keep going. On November 9th, 2023, the prosecution provided Mr. Allen's counsel with evidence of 44 pings generated by AT&T to locate LG's phone. So they're trying to find, this is from AT&T actual business record documents, and they tried to locate the phone, sent out 44 pings every 15 minutes looking for that phone. What would they find? There were 2 pings from February 13th, that's the day they went missing, 2017, in the pings provided to defense counsel, one at 5:48 p.m. and 7:16 p.m. Mr. Allen's counsel did not learn of additional pings, which took place every 15 minutes on February 13th until the discovery disclosure on April 26, 2024. Defense counsel still does not have the additional pings from February 13th or the early morning of February 14th. So they're missing data for a period of time, is what they're saying. Pursuant to the information which the prosecution disclosed to Mr. Allen's counsel, the first ping on February 14th was sent to LG's phone at 5:39 a.m. Now, there's some confusion here. You'll see that I noted in the timeline because they often have different numbers in here in this motion, which makes it a little hard to follow. Like they'll say this was the first time, and then they'll say some other time was the first time. But I note that in the timeline so you can kind of get a sense of where it happens. More importantly is Sergeant Blocker's statement that his interpretation of the information which they were receiving from AT&T indicated that the cell phone was no longer in the area or no longer in working condition, all in bold because that's the number one most important point they have. The prosecution's entire case rests on the idea that LG and AW were on or very near the south side of the Monon High Bridge at 2:13 p.m. and that Richard Allen killed them between that time and when a witness allegedly saw a man in blue jeans and a blue jacket on 300 North shortly before 3:57 p.m. In other words, assuming the prosecution's evidence is accurate, LG and AW were murdered after 2:13 p.m. and before 3:57 p.m. on February 13th, 2017. That's why I took you through the initial probable cause affidavit. I wanted you to see, yep, that is exactly what they said. That's a fair interpretation of what they said. They believed that the girls were killed in that period of time, that the bodies were left there, and Richard Allen was already wearing bloody, muddy clothes by the time he was spotted at 3:57 p.m. Additionally, assuming this timeline is accurate, the prosecution would have the girls between the Monon High Bridge and the location where the bodies were found from 2:13 p.m. on February 13th until they were found at approximately 12:15 p.m. on February 14th. In other words, the prosecution thinks they were killed there and they stayed there. It isn't like Richard Allen came back, moved them around. That's where they were killed. That's where they stayed until they were found. At the time the bodies of AW and LG were found, LG's phone was under LG's shoe, both of which were under the body of AW. So the cell phone, shoe, body, all right there at the scene. Assuming the prosecution's timeline is accurate, LG's phone was under LG's shoe, which was under the body of AW from sometime after 2:13 p.m. until the bodies were found at approximately 12:15 p.m. the next day, and had remained at that location in that condition for that entire time. And I think that's fair. I think that's exactly what they were saying. However, Sergeant Blocher stated on February 13th that the cell phone was no longer in the area or longer in working condition. There's no way LG's cell phone could have been out of the area between 9 p.m. and 1 a.m. on February 14th if the prosecution's timeline is accurate, because the phone was at the location where the bodies were found that entire time. That's pretty bombshell information, because if they're right, that means, and there's a lot of argument either way. We're going to go through it all. We're going to look at the prosecution motion, but I want you to see how bombshell this is, because they're saying if the phone was somewhere else, there's no way someone came back, stuffed the phone underneath there. I mean, there's just no evidence about that. And therefore, what they're saying is this phone proves there is no possibility that they were killed between 2:13 and 3:57. And we'll keep going to see why they say that. There is no way that the phone was not in working condition between 9 p.m. and 1 a.m. because we know the phone was on and communicating with the cell phone tower at 4:33 a.m. on February 14th. And I'm going to show you a couple more documents in just a minute where they are saying that the phone came on, that it suddenly woke up, so to speak, at 4:33 a.m. Well, if it's under a dead body and has been for hours, there's no reason for that phone to wake up. And that's really critically important if true. At the time of the search warrant for Mr. Allen's residence, members of the Indiana State Police were also aware that the last ping of LG's phone was not at 5:49 p.m., but at 4:35 a.m. the next day. The phone was accessed and connected with the cell phone power at 4:33 a.m. on February 14th. I mean, don't remember, we're going to have a timeline too, so you can kind of see how these things all fit together. I'll show you that in just a second. Had Tony Liggett submitted an affidavit for the search warrant that did not recklessly disregard the truth, it would have included the following. And this is where they're getting into the Franks motion. I will be honest, they have so little possibility of the Franks motion winning that I think the reasons for filing it are a couple. Number one, appeal, to say to an appellate court there were all these reasons. This judge is not going to grant it. And then the second reason would be to notify the public about information and evidence that they believe they have. I think those are two important reasons that they're doing it. So thank you, Michael. I appreciate that super chat. Thank you very much. And Jadzia has been a member for 5 months. That's fantastic. Thank you so much. I appreciate that. And we have another new member, the man with 2 birthdays. All right. I wonder how you've done that. That's very impressive. Okay, so we're almost finished with this motion, and I want to go ahead and talk about what they say should have been told to the judge. And here's what it is. On February 13th and 14th, 2017, law enforcement requested AT&T ping LG's phone every 15 minutes. The time of the last ping to the phone on February 13th was 5:44 p.m. And the time of the first ping on February 14th was at 4:33 a.m. I'm confused about why they say that, because earlier they said it happened every 15 minutes, and there were 44 of them, and some even still missing. But Indiana State Police believed that LG's cell phone was either out of the area of the Wells Street Tower or not in working condition between 5:44 p.m. on the 13th and 4:33 a.m. on the 14th, at which time there was a successful ping to the phone. These omissions are so voluminous and significant that there is no explanation for their omission other than a reckless disregard for the truth. Had Tony Liggett not recklessly withheld pertinent information from his probable cause affidavit on the search warrant, the application would have been denied. So let's pull up now. I'm going to move to our timeline. Is that it? That's not it. There we go. Okay. So I wanted to put this in timeline form because it so directly lends itself to timeline form. And I think it kind of helps us visualize too. I'm a total timeline person. That's just how I work. Jersey Jen has been a member for 4 months. That's awesome. That's fantastic. And Nana of 7 gifted 5 lawyerly memberships. Well, thank you. So be sure you have turned on the ability to receive memberships. Our Mama Pinks or Marlon, our moderators, will put that in the chat and explain how to do that. So YouTube randomly hands these out. We don't have any control over it, but hopefully you're the one who gets it. Okay. And of course, anyone can join. You can't join from your phone. There's not a join button on there, but you can go on the computer and hit the join button and become a member. We'd love to have you. It's just a way of financially supporting the channel. And we have some special different programs. We're going to be doing our next one next week. So you will be just in time if you join today. So let's go over our timeline. On the 13th, this is the day the girls disappear. AW and LG were on the south side of the Monon High Bridge. They're taking a walk. Between 2:13 and 3:57 is when the defense says 3 phones are in this area and none of them belongs to Richard Allen. We don't know much more than that about what exactly was found. 3:57 p.m., a witness sees a man in blue jeans and a blue jacket on 300 North. I need to add that the person says that he has muddy, bloody clothing. At 5:48 p.m., AT&T pings LG's phone, and the blocker report says this was the last contact for the day. Blocker states the cell phone was no longer in the area or no longer in working condition after that. Now, and I note in here where sometimes a different number is put in a different paragraph. 7:16 p.m., AT&T pings LG's phone. 9 p.m., Steve Mullen, and I pulled this out of the document. They also said they pinged it every 15 minutes. 9 p.m., Steve Mullen for Delphi Police Department contacts Sergeant Mitch Blocker of the Indiana State Police, trying to get precise location for a cell phone. Request phone be pinged every 15 minutes. So I'm not sure exactly what the earlier pings are. Maybe they were random because it was just something that AT&T sent out and was able to record, but not an intentional every 15-minute ping. So from 9 until 1 a.m. is when they believe a gap occurred. Then at 1 a.m., Mullen's last contact with Blocker is before this time. At 4:33 a.m., AT&T pings LG's phone. So really the gap goes up to 4:33 a.m. to be more precise. The defense says this: the phone was accessed and connected with the cell phone tower, and this means the phone is working. And the defense says this was the last ping. Contradicted. Now that's contradicted elsewhere in the document, and says this was the first ping of the day. So there were some confusing things, but bottom line for sure, the defense believes 4:33 a.m. is critically important. Now, I was so grateful this wasn't broadcast, but some people took notes at the hearing and posted them on X. So we were able to get a little bit more information. Here is these were the notes. Darn it. Here we go. From R&M, notes that were posted on X. And the notes say at 4:33 a.m., the cell phone was turned on and SMS flooded in. And it was either off or out of town range on the 13th around 5:30 p.m. So they're saying someone turned the phone on, did something to the phone that would cause data to flood in, turned it on, manipulated it, whatever they did to it at 4:33 a.m. That can't happen if the phone is underneath a dead body. Now, don't hold on, because we're also going to get the prosecution argument against this. But I want you to understand what it is that they're saying about this, and then we'll head back to our timeline. Okay, so AT&T, the bodies are found. Well, okay, I think I skipped 5:39 a.m. AT&T pings LG's phone for the first time this day. That contradicts the 4:33 a.m. And then at 12, but I'm telling you, these were all in the document. So I put them in there to note for us some inconsistencies that I can explain. At 12:17 p.m., the bodies were found. The phone is under LG's shoe, which is under AW. That's the facts that we've been told. And then the rest just relates to when the motions to compel were filed, when this evidence was produced, and so forth. So now I want to head into what the state says in response, okay? Because we obviously need to hear both sides. And let's head over here. Here we go. So this is the state's response. And they start out, and these are the kind of comments that you have throughout this. This fourth motion illustrates a complete misunderstanding of the ruling in Franks versus Delaware. Contrary to what the defense's motion states, the defense have known about the pings well before the April 26, 2024 discovery disclosure. And it may well be that they knew such a thing had happened, but didn't know the details about it. That may be what they're trying to say. When AT&T pings a phone, the prosecution explains, they will send a signal from the tower nearest the cellular device to that cellular device. From the time it takes the signal to reach the device and get back to the tower, they will determine a location of that device. The location can be accurate at times, but can be completely inaccurate at times. If the tower cannot make cellular contact with the device, then the ping data will show a historical data location. So in other words, if it's pinging and it's not finding you, it'll just keep showing where you were. And you've seen that if you use a tracker or something, the person stays here and you figure they've moved on, but it's not finding them. So the little dot representing that person stays right where it is. It doesn't move. So if that is not a pinpoint location, they're saying it's a memory, more or less. It's historical. It's not true location. The location given comes with an inaccuracy range anywhere from 400 meters up to 25,000 meters. Those inaccuracy ranges can differ based on several factors. A tower can lose contact with a device because the device runs out of power or because the device loses cellular service, which doesn't make sense here if they're right. The defense is that it comes on again at 4:33. So law enforcement uses this as a tool in certain cases to attempt to locate a cellular device. It's not always an accurate way to locate a device, but can be used as a tool to help determine the location of a device. And then data sources telling us that that's coming from historical records. This is a quote, that's not coming from the device like live and active. They're providing information that's coming from. They're going back and they're collecting information from the historical call detail records. So they're saying this is just a memory. This is not information specific to the phone. The thing is, that doesn't really seem to address what the defense is saying about the gap. The fact that there's historical data it isn't like the defense was arguing that there was a new place where it occurred or should be. I just didn't think that this really seemed to match what the defense was arguing had happened. But we'll keep reading. The ping emails collected all show historical data. That means that the tower could not find the phone at the moment the ping was initiated. So it just gave the service provider the historical data location. That doesn't mean the phone wasn't in the area or that the phone wasn't in working condition. It means that the tower could not contact the phone, which raises the question, why and what happened at 4:33 a.m.? The defense then goes on to mischaracterize Sergeant Blocker's statement, and I have no idea how to say his name. I have to find that out. I think I've said it at least 3 ways so far here. Contained in fact, maybe that's what I'll do. Every time I get to it, I'll say it a different way. That way, surely one of them will be correct. Sergeant Bloker reports that from his evaluation, the last contact that the phone had with the cellular tower was at 5:44 p.m. on February 13th. The records from AT&T show that there has been no contact with the tower since then. From that information, he determined that the phone was no longer in the area or no longer in working condition. The defense wants this to mean that the phone is not in the area from the evening of February 13th, 2017 until the morning of February 14th, 2017. That is not what it means. It means that since the pings were only showing the historical data location, the phone was not having contact with the tower. Sergeant Blocker explained that that could be because the phone was not in the area, but it could also mean that the phone was not working. So there are really two issues. One is what made the phone suddenly turn on at 4:33, and the other is where was the phone during that period of time when they were just getting what they believed to be historical data. Now they say it hadn't moved. It just wasn't working during that period, and therefore we were pinging it and nothing was responding. It did not mean it had been moved. It just means this is where it had been before. That's all that was happening. That's what the prosecution is saying. There is no evidence that the girls were ever taken from the area or that they were brought back to the area later to be murdered. Every indication is that they were ordered down the hill and then murdered soon after. The defense has not met its burden. The omitted information from the AT&T pings does not negate the fact that Richard Allen places himself on the bridge at the same time that Libby German took the video of Bridge Guy who ordered the girls down the hill. Further, Richard Allen admits that he was wearing clothing matching the clothing that Bridge Guy was wearing that day. That, along with other eyewitness testimony and the other evidence gathered, establishes probable cause that Richard Allen is bridge guy and he is the one who kidnapped the girls. Now that right there is why I think the judge, there's no possibility that she's going to grant this motion and say, oh, you're right, there should never have been a search warrant issued, because they're going to say there was plenty of other evidence that connected him to the scene. It was at least enough to get a search warrant. And I think that's probably right. Okay, so we've got the state's position, which was this was historical data, but they don't really address the 433 wake-up call. We'll call it that. They don't really explain, okay, why did that happen? What was the reason that it woke up? Because there are two different possibilities here. One is that the girls weren't there at all, that they were moved in this period of time and the phone was brought back and put there, and that's what suddenly woke it up, or maybe even someone opened it or unlocked it. So that could have happened, or maybe someone manipulated the phone at 433, but it just seems like we're missing pretty critical information right here. It seems like this is an important point from the state, and we don't really, from the defense, and we don't really I don't understand yet what the state is saying in response. I get their point about historical data, but that's about it. Okay, so Paper Chaser has been a member for 5 months. Fantastic. And likes the timeline. I'm glad you like that. I'm big into timelines. They help me a lot, so that's one of the reasons I'm into it. Oh, look at that. Maybe I complained enough that YouTube did something. Laura Lee Annie is saying that she was able to join from the phone. Could you let us know in the chat, Laura Lee, if you have an Android or an iPhone? So I would be curious about that. That is fantastic, though. First of all, that you've been a member for 2 months. And secondly, also that you were able to join from the phone. Thank you, Lee Dundee. I appreciate that very much. All right, so we've got a final motion to go through, and there were multiple motions this week. We're not going to cover every single one, but we're going to cover over time the biggest ones of all, and this is one of them. This was, I thought, bombshell information. It's just a question of the prosecution says the defense just doesn't get what this data is about. They don't understand that this was just historical data. And the defense says, are you kidding? Someone turned the phone on at 4:33 a.m. the next morning. That means somebody turned it on at 4:33, and yet it ended up under the body that was discovered later that day. Something else is going on here. So that's a pretty huge dispute. All right, so let's look at the reply brief filed. Oh, and here, yet again, someone who posted on X. Let's see if I can tell from here. Susan, darn it. Is there some way that I can open that up? I don't remember what her last name was. It obviously starts with BA, but it is not giving me the chance to. Oh, well, anyway, let's just take a look at this. And let me, she also attended the hearing, and here are her notes. She says, Baldwin, that's the attorney representing, one of the two attorneys representing Richard Allen, says the expert analyzing cell phone pings did not know LG's phone reconnected then until May of 2024. Baldwin raised the idea that the phone was not in that area where the girls were found from the afternoon of February 13th until early AM on February 14th. Baldwin questioned how, with so many searchers out on February 13th, no one found bodies 200 yards from the bridge until the next day. So what Richard Allen's team is arguing is it's not just that we have this cell phone data, that this cell phone that suddenly turns on at 4:33. Is that true? I don't know. I'm just simply telling you how this argument seemed to play out. But they're saying it's not just that, but they're also saying everybody would have seen these bodies just 200 yards off the bridge. We had tons of people out there searching. If they had really been there, somebody would have noticed those bodies weren't there on the night of the 13th when people were searching. That's the argument being made. Baldwin said the autopsy report does not give a time of death, which is extremely significant, or could be in this case. And I'm going to go ahead and skip that. There is a definite argument about third-party culprits, and that was one of the things that was discussed. So we will talk about that later, but on another day. So here's the reply brief that the defense wrote. that explained again. And they said the prosecution turned over the blocker report approximately 14 months after the state was required to turn over the evidence. And this newly discovered evidence shows that on February 13th, one of the victims' phones was outside the area of where the bodies were ultimately found. Judge Diener had a right to know this information before issuing a search warrant, as said evidence completely throws off the state's timeline of events, thereby exonerating Richard Allen. This is important because law enforcement have maintained from the beginning of the case that the girls were murdered on February 13th, 2017, and remained in the place they were found from the following day, never leaving the area where they were ultimately found. This new evidence, therefore, would show that the phone and the victims were taken outside of the area where they were ultimately found, but then brought back to the area at a later time. Huge, 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 because they have put it, as we saw, and that's why I went back to that probable cause affidavit. The prosecution carefully narrowed everything to that period of time. Richard Allen is walking away with bloody clothes at 3:57. It's over. And the defense is saying, we have proof it wasn't over by 3:57. We have proof that the phone was active, moving around for hours after Richard Allen left the bridge. That means he's not the guy, just like he said. And we have these 3 other phones in the area that are not connected to Richard Allen. In his response to the 4th Frank's request, the prosecution made several assertions that simply aren't accurate or true. The prosecutor is not a digital forensic expert, and his assertions should not be accepted as true or accurate by this court until he presents evidence and or testimony that supports his assertions. Similarly, the defense attorneys are not digital forensic experts as well, and therefore the defense would also request this court to not accept their assertions as fact. Okay, so let's pull out. All right. Bombshell, am I right? Because if this is for real, Susan Batt, there we go. I had it in my notes. So thank you, Susan Batt, for posting your notes on X. That was really helpful. It's so frustrating when we can't see the hearing and just have to kind of, piece together news articles and stuff to try to understand exactly what was argued there. Although I saw very little recount, this may not have been specifically argued other than the sort of basic argument that we saw there. This really does need to be fleshed out by experts who truly understand it, because this is an incredibly important point. Very important, depending on whether or not the phone woke up at 4:33 a.m. It could completely change everything. All right. Jersey Jen gifted a lawyerly membership. Thank you. I appreciate that very much. Be sure to turn that on. Sky Goddess 87, thank you for the super sticker. Well, let's do some questions now. So if you would put question marks at the beginning of your question, I've got a much better shot of finding it if you do it then. Oh, thank you, Teddy. I appreciate that very much. I'm glad you're enjoying the channel. Okay, so looking forward to the questions here. Don't forget question marks at the beginning. All right, and I see Tro noted that the arrest was made a certain number of days before the sheriff's re-election or election campaign. And certainly there have been people who argued that, much like the Karen Reed case, there were political reasons. There were things related to self-protection of troopers and law enforcement and prosecutors that had played a role in this. Maybe not so much prosecutors, but the sheriff's office. So it's sort of similar in that sense, that there are arguments like that that are being made by the defense. And we'll have to see how they shake out, whether they prove to be true over time. All right. So we are looking for SP Mama. How long do you think it will take for a trial to happen? That is actually supposed to happen. They've already set the dates out. I think it's October 14th through November 14th. Initially, she had only put 2 weeks for that. I thought, wow, there is zero way this trial is happening in 2 weeks. And she had given the prosecution like most of the time and just a tiny bit for the defense. And the defense complained it's now set for 4 weeks. And initially, she was running it 6 days a week, Monday through Saturday. She hates this case. You have to assume she hates it. So she was running Monday through Saturday. You got 1 day a week off. And now she's doing a Monday through Friday, more regular routine. in the new schedule. So I am thinking very seriously about going up there for the trial. It won't be broadcast, so that's really the only way I can get kind of firsthand information. So if that would interest you, put that in the chat. I'm curious. I haven't made a decision yet. It would be obviously a significant commitment, but I am so curious about it, and I don't know quite how to get the information I'd like to get and present to you without that. So anyway, it's just something I've been musing over. So give me your thoughts and your comments, please. All right, Michael, how is my family doing? I think my family is doing okay. We dealt with the death of my husband a couple of months back, 3 months back, but we are doing well, and we are moving on to and remembering him every single day, and that's been good. We talk a lot and have good memories. So thank you for asking. Kimberly, could have a satellite passed over and woken up the phone, or was it turned off and died and then turned back on at 4 a.m.? I don't know. I have no idea. That's exactly, I mean, those are good questions, Kimberly, but I think that's exactly what we have to have a true expert to answer. And I sure hope they don't end up with two experts on each side. One says, oh yes, satellite went over, and the other, no, satellite went over. I would actually like to know the answer. I mean, how did this wake up at 4:33? If is that it? First of all, is that even true? Did it wake up at 4:33? And if it did, what are the possible methods that could happen? So that's really, really important. Okay, Rosie asking me, do you think the guards overheard Richard talking about the Odinists, did it, and wore the patches just to mess with him? Oh, wow. That would certainly, who knows? Who knows? They did remove them. You know, as I recall, in the state's response, there seemed to be some suggestion that these really were Odinists and that they were wearing these patches for real. But I can't remember that in detail. I don't know why they did it. Mickey Bassett, they have removed them. So Mickey asked me, how did RA pull this off by himself? Is there info that I missed? It seems like a huge task. That is one of the things the defense made a big point of in Frank's one. They said, you know, you've got two girls killed separately. Their clothes are all mismatched and moved around. They are in different, they're both murdered, but then there are all these sticks and stuff placed on top of them. And then there's this blood on the tree. How does one person do that in 2 hours? How can you get all that done that fast? 2.5 hours. And so that is one of the arguments that the defense will make, is there's no possibility. It's too much. Without more understanding of what the crime scene looked like, it's kind of hard to evaluate that. Although just off the cuff, it does seem like a lot for one person to do in such a short period of time. Connie has an iPhone and joined with her iPhone. I'm going to have to stop maligning YouTube. They have now given us the join button on the phone. That is fantastic. I'm really glad to hear that. The man with two birthdays wants to know if I have a Southern accent. Yes, I do. Yes, I do. Carolina says, were RA's confessions coerced? And do you know if they have any other suspects? Well, Carolina, that is, in fact, something that was addressed at length. There were motions and about the confession. The defense said, we want all the confessions put aside because we believe they were coerced. The state obviously argued against that. We're going to cover that one in depth. That's going to take a whole night because it's a very, very important point. The prosecution says he confessed 61 times. The defense says, yeah, that's after you tortured him basically and put him in solitary confinement. And that's when he began to confess. So we'll talk about that whole argument. Jackie, doesn't an illegal search and seizure nullify the evidence? If the evidence could not be presented at trial if the search was deemed to be illegal, they wouldn't be allowed to use the bullet, the gun that they believe were connected. They wouldn't be allowed to even talk about that, which would leave the only facts would be that Richard Allen was present and wearing clothes that may or may not, depending on which witness you're listening to, have been similar. So other than that, that would be about all the evidence that they would have. I guess you've got the video, which shows a man, which arguably, depending on which side you're on, could or could not be Richard Allen. Possibly you could hear his voice and maybe tell that from the recording. Other than that, there wouldn't be a lot of strong evidence connecting him to such a significant crime. Laura Lee Annie wants to know, what's the best way to get a good sense of this case? I haven't watched before tonight. Probably, I've got several videos. Go back and watch the videos that I've done, because I try to kind of build up. And if you go back and watch, we aren't too far into it, so it won't take you all that long. But I have playlists, and look up the Richard Allen Delphi Murders playlist, and you'll be able to kind of work your way through it and get up to this point. So I do try to give at least a little bit of an overview at the beginning for people who are new, but this is one of those really deep Byzantine, lots of tentacles kind of cases where it starts to add up, new point on top of new point on top of new point. So I know that it can be a lot. Libby asking, can the CSI team determine if the bodies were moved? I presume we will get testimony that they believe the bodies weren't moved post-death. I guess. I don't know exactly what information we'll get, but I think that they will have arguments probably on both sides about whether or not the girls were killed where they were found. And we will find that out. More to come. More to come. All right. Looking for those question marks at the beginning. Thank you for your condolences. I appreciate that. And I'm looking for the question marks at the beginning. So wait a minute. A case like this. Oh, okay. I was about to say there are definitely going to be questions. Did the judge allow the Odinism theory, or did the judge throw that out? And that was one of the motions filed by the state, was to keep out basically every good piece of evidence that the defense had, which is, a strategy when you do motions in limine. What you're trying to do is prevent evidence that would hurt your side, and you file motions saying, here's why it should not come in at trial. And that's what they did. They filed and pretty much everything that could possibly be relevant, like the third-party culprits or like the Odinism, all of that. The state said, we want all of that out. I think it would be wildly improper if the judge did that. I don't think she's going to do that, but I have not heard about a ruling on it yet. A lot of these she took under advisement. She may rule out pieces of it, but I think ruling out the whole thing, I would be very surprised if she did that. I think it's relevant enough that a lot of that will come in. Now, the third-party culprit may be a little more difficult. That's a little bit harder ruling. But to me, the Odinism and the Nordic runes and that kind of thing, that's going to be something that the jury is going to need to want to know. All right, looking for those question marks. And we'll take one or two more. Margaret, it seems they were at a sleepover and were taken from there. Margaret, they were last dropped off while they were taking a walk, and there wasn't there was no one who saw them after they were dropped off. They were supposed to come home or meet somebody who was picking them up, and that was it. So I don't think there was anything like that. John Phillips with the phone pinging, why hasn't that shown where the girls were? I'm sure they had already been reported missing at that time. Why didn't they ask for that before? I think they did. I think from that report, they asked for that the very night. They said, could you ping the phones, see if you can find it? And what they were getting was just historical data, and they weren't able to locate the girls based on that. Maybe it just got to the point of the park and they said, okay, well, there they are. We knew they were there. What we don't know is where they are right this minute. Maybe if it had been a little more precise, it would have shown the exact location. That would have been very useful for them, but I don't, evidently that's not in any way how they found it. Okay, so last question. April Osteen, does he have public defenders or did he hire lawyers? The answer is sort of a yes, because what happened was he actually hired, I think he initially hired a lawyer, but it was way too expensive. And so he said, okay, yeah, I'm going to need the court to appoint. The court appointed these lawyers, and the state is paying for these, or perhaps the county is paying for these lawyers. And then several times the judge has kicked them off, but he's not paying, but they are not public defenders per se. This isn't their whole job. They are attorneys appointed to this case. So next week, 7 p.m. Eastern, On Monday, it's going to be a toss-up. Tell me what you want to hear about. Sarah Boone has a hearing, which she will be handling pro se, a status conference on Monday. We haven't covered that case much, but boy, is it interesting. And the fact that she's going to be doing this case herself, having run through 8 different lawyers, that alone is going to make the case pretty interesting. The allegation against her is that she put her boyfriend in a suitcase and left him to die there, that he asked to get out. She says they were playing a game. She didn't let him out, and she videoed it. So that's that case. And please vote for that in the chat or the comments. Let me know. And then, but I definitely want to get back to this case, the Delphi murders case. We've got a lot more issues to cover. I definitely want to talk about the 61 confessions and what the arguments were on both sides for those coming in or for those not coming in. So I will see you Monday at 7 p.m. Eastern for lots more cases to cover.